Hello and welcome to Courts This Week. I'm Dina Osha. In this special edition, we bring you top stories of the legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Court. We bring a selection of major legal proceedings which made headlines this week. In the next half an hour, we will also inform and update you on all important proceedings from the week. So let's start Courts This Week. The Supreme Court has held that the state government will not allow to promote students without holding final year university examinations amid the COVID-19 pandemic. However, the court gave states the discretion to approach the University Grants Commission for an extension of the deadline by which final year exams should be completed. The order was pronounced by a bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah. On August 18, the bench had reserved its judgment in the matter after a detailed hearing spanning over 2 days. The bench held that the decision taken by the state of Maharashtra to cancel exams amid the pandemic under the Disaster Management Act shall prevail. Supreme Court has upheld UGC decision to hold final year exams by September 30. The court held that the states must hold exam to promote students. It added that if any state feels they cannot conduct exam, they must approach UGC for suitable reliefs. Court disposed of the petitions challenging the guidelines issued by the University Grants Commission for conducting final semester exams by September 30 with following orders. The bench has refused a prayer to quash the UGC guidelines to hold exams. The directions of the State Disaster Management Authority for cancelling exams in that particular state will prevail over the UGC directions. However, the directions of the State Disaster Management Authority to pass the students on the basis of previous performance is beyond the scope of the Disaster Management Act. States, union territories cannot promote final year students without examination as ordered by UGC. States, union territories given liberty to approach the UGC to seek postponement of the exam in the light of the COVID-19 pandemic situation. A host of senior counsel, including Abhishek Manu Sangvi, Shyam Diwan and Arvind Dattar, argued in favor of the interests of the students. They pointed out that a decision taken by some states' government to cancel the exam was only on account of the rising COVID-19 figures. Under normal circumstances, a deferment or cancellation of exam would not be stipulated. Compelling students to appear for physical exam when the COVID-19 pandemic is intensifying exposes them to serious health risks affecting their right to life. The uniform direction issued by the UGC without taking into account local situations will put several students to grave prejudice, as several areas are on containment zones and local lockdown is in prevalence in many regions. The pandemic and the lockdown have disrupted the classes, and conducting exams without requisite numbers of the classes is arbitrary and unreasonable. There are many students of final semester who have either cleared job interviews or secured admissions for higher courses. So granting them degree certificate at the earliest based on past performance is the best course available to protect the future of the students. The option of online exam is not viable given the stark digital divide and the lack of the uniform access to the internet across the spectrum. Examination is not only the mode of evaluation. UGC follows the concept of the continuous evaluations of the students from day one. Hence, the internal assessment and performance of the past semesters can be reckoned to award final degrees. In its reply, UGC averred that the state government are taking contradictory stands with regard to starting the academic sessions and conduct of the final year exams. Initially, a total of 31 students from different universities across India had approached the Supreme Court to quash the UGC circular directing university to wrap up final year examinations by September 30. Bureau Report. The Supreme Court has dismissed 2 pleas seeking for a direction to the Chief Election Commissioner for the postponement of the impending Bihar Assembly election on account of the COVID-19 pandemic and the state being ravaged due to floods. A bench comprising of Justice Ashok Bhushan, R. Subhash Reddy and M.R. Shah heard the matter and observed that the plea was premature as the Election Commission of India had yet to issue a notification announcing the declarations of the election in the state. The Supreme Court has refused to entertain a petition seeking deferment of the Bihar Assembly election due to the COVID-19 and floods. The bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah declined to entertain the petition, terming it as a premature and misconceived. The petitioner argued before the court that the representations of the People's Act 1951 allowed for elections to be deferred due to the extraordinary situations. He further submitted, election was not paramount, human life is paramount. Even MLAs are dying and people are suffering. However, the bench was not inclined to allow the plea and informed the council that such orders cannot be passed and that it was for the ECI to decide. The court questions how the prayer can be granted when the notifications for holding of elections has not even been issued yet. Moreover, the bench opined that COVID-19 cannot be the reason for deferring polls and that Election Commission of India would factor in the prevailing situation while announcing dates for the polls. Justice Bhushan observed COVID cannot be ground for postponement of the elections, especially when the notification declaring the election is not even issued. This is a misconceived petitions under Article 32. We cannot entertain this petition. When counsel for the petitioner sought to highlight the steps taken by the authorities in various other countries where important national events stood deferred or cancelled on account of the COVID-19 pandemic, the court said that ECI would take care of all these situations. The Election Commission will take all the necessary precautions and consider everything. Why do you think they will not consider these things? Justice M.R. Shah said. The court then allowed the petitioners to withdraw the plea. The petitioner prayed for a direction to the ECI to recommend against holding of the polls in Bihar until the state is declared free of COVID-19 and floods. The state is reeling under severe and extraordinary circumstances on account of not only the COVID-19 pandemic but also the recent floods, stated the petition filed through advocate Shantanu Sagar. The petitioner had further raised the questions whether it is the ECI exercising its power under Article 324 of the Constitution or the President or the Governor that decides the schedule for polls after ECI's recommendation. Bureau Report. The Supreme Court has held that a state legislature may make laws to give preferential reservations to subcastes within categories. In doing so, the court has diverged from another Constitution bench judgment that held the contrary. This decision rendered by the Constitution bench of Justices Arun Mishra, Indra Banerjee, Vinith Saran, M.R. Shah and Krishna Murari. The questions for reconsiderations before the bench was whether the Supreme Court's 2004 judgment in the case of E.V. Chennaiah versus the state of Andhra Pradesh needed to be revisited. In that judgment, the Apex Court had held it to be unconstitutional for state legislatures to provide a further subcategorizations of the scheduled caste and scheduled tribes. While pronouncing the judgment, Justice Mishra said that the bench is of the view that once the state has the power to give reservations, it can also make subclassifications to extend benefits to those subcastes not receiving the benefit. The issue has now been placed before the Chief Justice for forming a larger bench to definitively decide the question. The question was posed before the Supreme Court in a batch of appeals against the decision of the Punjab and Haryana High Court, which struck down Section 4(5) of the Punjab Scheduled Caste and Backward Classes Reservation in Services Act of 2006 as being unconstitutional. This provision had carved out a preference in favor of the Balmiki and Mazbi Sikhs from 50% quota reserved for the SC communities in case of direct recruitments. This provision was struck down by the High Court based on the E.V. Chennaiah, which held that all the scheduled castes enlisted under Article 341(1) of the Constitution of the India from one homogeneous group and his group cannot be severed into a subdivision or the subclassifications. However, a three-judge bench of the Supreme Court in 2014 referred the decision laid down in E.V. Chennaiah to a larger bench for considerations in light of the Article 338 and the law laid down in the Indra Sawhney judgment. After hearing the parties on the questions of the constitutional validity of the provision in questions, the state's legislature power to enact such provisions and on whether E.V. Chennaiah needs to be revisited, the judgment in the matter was reserved on August 17. The Supreme Court has pulled up Centre for hiding behind the RBI. It has asked for categorically reply on the interest waiver during the loan moratorium period. The court observed that at a time when the country is reeling under a pandemic and the people are suffering, the positions of the authorities cannot be that of focusing on business alone. The Supreme Court pulled up the central government for not having made its stance clear in the issue pertaining to interest on long-term loans during the COVID-19 moratorium period. The matter was heard by a bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah. The bench today pulled up the Centre for hiding behind the RBI instead of making its own stand clear. However, Solicitor General Tushar Mehta sought to assure the court that the centre is working in coordination with the Reserve Bank of India. At a time when the country is reeling under a pandemic and people are suffering, the position of the authorities cannot be that of focusing on business alone, the court observed. Justice Shah said, "This is not the time to think about business only. The centre ought to submit its reply on two important aspects," the court asserted. These are the questions of Disaster Management Act and the waiver of the interest on interest. During the last hearing in this case, the court has asked the centre and the RBI to review the move to charge interest on loan repayment during the moratorium period introduced in light of the COVID-19 pandemic. The Indian Bank Association was also asked to look into the possibility of evolving new guidelines to address the issue. The court had been considering the questions of charging interest on those who avail the benefits of moratorium allowed by the RBI for deferred payment of term loans. Tushar Mehta had told the court that the difficulty in interest waivers arises from the fact that people who have taken loans include those who have taken small-time loans as well as those who have borrowed amounts ranging in hundreds of crores. The benefit allowed through RBI circular is that only of the moratorium on payment of installments, but the interest on this deferred payment would be compounded, SG has explained to the court. He also highlighted the duty of the banks towards paying of interest to their customers. However, the court has questioned the need to change interest during these difficult times. You are giving them a favor by deferring the payment. It is an irony that thousands of crores have been defaulted on NPA accounts, but you have to charge interest here. We are aware of the problems if interest is not charged, but a pandemic is not a normal situation. Supplementing Mehta's submission, senior advocate Harish Salve, representing the IBA, said that deferment is merely pushing off payments of installment. The banks are still obligated to pay compounded interest to their depositors, for which an arrangement would have to be made during this moratorium period, Salve added. Salve termed this pleas for interest waiver premature in nature. Subsequently, the court further restricted the scope of the issue and said that the court is not asking for a complete interest waiver, but waiver of interest accrued on the interest amount. It thus asks if banks can handle this limited burden. In view of the COVID-19 pandemic, the RBI had issued a circular on March 27, allowing banks to moratorium to borrowers on the payment of installment for a period of 3 months, which was later extended to 6 months. The RBI has also made it clear that interest accruing on these loans for this period would be payable. The part of the circular regarding charging of interest was challenged by some petitioners who claim that their monthly EMI payment will stand increased as a result. Bureau Report. The Supreme Court has reserved its verdict on the sentence to be imposed on the advocate Prashant Bhushan in the contempt case filed against him for his tweets criticizing the judiciary. The order was reserved by a bench of Justices Arun Mishra, B.R. Gawai and Krishna Murari, who heard senior advocate Rajiv Dhawant and Attorney General of India K.K. Venugopal at length. Supreme Court bench headed by Justice Arun Mishra reserved a judgment in the 2020 contempt case against Prashant Bhushan over his tweets. Starting the day's proceedings, Attorney General K.K. Venugopal reiterated his appeal to the apex court to take a compassionate view and forgive Bhushan However, the court said the lawyer has not apologized yet and has even made disparaging remarks in the affidavit filed in his defense. Venugopal had urged the top court last week as well as to spare Bhushan from any punitive action. The bench then sought views of senior advocate Rajiv Dhawan, counsel for Bhushan, on punishment to be awarded in the contempt case. Dhawan said judgment convicting Bhushan should be recalled, no sentence be imposed on him. Please do not make Prashant Bhushan a martyr. After Babri Masjid was demolished, there were crowds to welcome Kalyan Singh, so don't make him a martyr, he said. Arguing the case, Dr. Dhawan said, these offenders have contributed a lot to this court as amicus and in public causes. As the Attorney General pointed, Dhawan remarked, I remind Justice Arun Mishra that when he was a Chief Justice of Calcutta High Court, your lordships did not initiate contempt against the Chief Minister, Mamta Banerjee, for her comments that judges are corrupt. Observations on the August 20 order of the Supreme Court were submitted by Dhawan before the court as he stated that the order giving time to Bhushan to apologize gave the impression that Bhushan was being coerced to give an apology and it was an exercise of coercion. Dhawan then went on to submit that the court was not immune from criticism and that it was the responsibility of all to make responsible criticism. In the present controversy, many persons like Justice Lokur, Khurain Joseph, Arun Shore, etc. have made comments in the public domain. Is that also contempt? He asked. The court then sought the views of Attorney General K.K. Venugopal on how to proceed with the matter. The AG responded, Bhushan may be given a warning first and let go. He need not be punished. Justice Mishra went on to say, when Mr. Bhushan does not think he did anything wrong, then what is the point of giving him advice to not repeat it? Then Venugopal said that Bhushan would not do it again. The court replied, let him say that, but he then instead of that, he gave colors to those tweets. Meanwhile, a new Supreme Court bench will hear the 2009 contempt case against Bhushan from next month as Justice Arun Mishra retires in the first week of September. The bench headed by Justice Mishra said that the matter will be listed before an appropriate bench on September 10th as they are short of time. Bureau Report. To organize the trials of the foreign Tablighi's hearing on consolidations of the case is in progress. The Supreme Court has asked the Bihar government to file reply in this matter, especially regarding the trans of the cases from the Patna to Delhi. The central government has blacklisted 960 foreign Tablighis hailing from 35 countries. Tablighis have requested for the cases open in Patna to be transferred to Delhi on humanitarian grounds. Regarding the process, Solicitor General Tushar Mehta had said in the court that consolidations has underlying logistic issues. The Supreme Court has directed the state of Bihar to file its response on the issue of the consolidations of the ongoing trials against Tablighi Jamaat members from Patna to Delhi. A bench of Justices A.M. Khanvilkar, Dinesh Maheshwari and Sanjeev Khanna asked Advocate Shivam Singh, appearing for the state of Bihar, to file his response on this aspect and listed the matter on August 30. Senior advocate Manika Guruswamy appeared for the petitioners and stated that trials against a few foreigners were going on in Patna and sought their consolidations in Delhi on humanitarian grounds. Solicitor General Tushar Mehta, appearing for the centre, stated to consolidate all trials would come with its own logistical issues. In Delhi, the cases were spread across 4 to 5 different magistrates. If in more than one cities, there will be logistical issues, said Mehta. On August 6, the centre had informed Supreme Court that lookout notices issued against the foreign nationals for their alleged involvement in Tablighi Jamaat activities at Delhi's Nizamuddin Markaz have been withdrawn. Upon being asked about the status of trials, Mehta had then informed the court that 10 out of the 34 petitioners have chosen to contest the criminal cases against them instead of opting for a plea bargain. The law officer had further stated that these trials were before different courts in Delhi and suggested that they may be brought before one court to be disposed of expeditiously. On April 2nd, government decided to blacklist as many as 960 foreigners from 35 countries who were present in India. At the same time, orders were issued to Director General of Police of all states and union territories as well as the Commissioner of Delhi Police to register FIRs against such foreign nationals. Contending that the decision had been taken unilaterally and arbitrarily, the foreign nationals urged the top court to declare the decision as unconstitutional and void. Their plea emphasized that a decision of an en masse blacklisting without issuing notice. The center had stated in reply to the plea that there existed no fundamental rights on the part of a foreigner to obtain a visa or to continue a cancelled or rescinded visa. Highlighting the specific nature of the breach committed by the present petitioners and the reasons for the action taken by the center, the central government stated that the petitioners had indulged in activities in the nature of the tablighi activities which are not permitted on tourist visas and are liable for legal actions against them. It was pointed out that apart from visa violations, the activities of the petitioners in the nature of the tablighi activities in questions have endangered many lives in the ongoing COVID-19 pandemic and therefore are liable to legal actions. With regard to invocations of Article 32 for their benefits, the center states that no legal immigrants can crave the leave of the top court to question the decision taken by a statutory scheme. Bureau Report. Well, that's all in quotes this week. Thank you so much for tuning in. Keep watching APN and stay safe.